Okay, good morning. It's 11 a.m. on November 16, 2021. Welcome to another oral argument session of the 5th DCA by Zoom. I am Judge Lambert. I will be presiding over this appeal or oral argument today. With me on the panel are Judges Harris and Sasso. This case is number 21-69, Florida Hospital Medical Center as assignee of Louis Pina versus Progressive Select Insurance Company. Remind everybody that we are live on YouTube, so use good judgment in anything you say to us during your arguments. If you have any electronic devices on, please put those in either the silent or turn them off so that they do not interrupt either yourself, your opposing counsel, or the court during the oral argument. Each side will have 20 minutes. You see there's a clock up there on the left-hand side. I will reserve 5 minutes for Mr. Barr on behalf of the appellant, unless he tells me a different amount of time that he would like for his rebuttal. So that being said, if we're ready to proceed, Mr. Barr, go ahead, sir.
Thank you, Judge. May it please the court. My name is Chad Barr, and I have the pleasure of representing Florida Hospital Medical Center in this appeal. As it relates to the rebuttal time, Judge, I don't anticipate using all my time, so whatever time you allow me at the end will be sufficient for me.
All right.
We're here today, Judge, asking the court to reverse and remand the trial court's August 28 order refusing to award the appellant its expert costs in this matter. Just for some context, I'd like to just briefly go over the background of this case. This case is about 5 years old, and this is actually the second time this case has been before this court. For about 3 years, we battled through 3 different levels of appeal the issue of how to apply a PIP deductible in a PIP case. Progressive lost at each level, and as this court's aware, in late 2018, the Florida Supreme Court approved this court's decision in this case and in the companion case, Jonathan Parent, with regard to how a PIP deductible should be applied in these cases. So this case took a long time to get back to the trial court to decide the only issue left, which was the amount of attorney's fees that Progressive was required to pay under 627.428. The trial court attorney for Florida Hospital resolved its fees with Progressive, and all that was left was the appellate attorney's fees that my office had incurred on behalf of the appellant in this case. So we went back to the trial court. It took us, Judge, almost 2 years to get this case set for a fee hearing. Once we finally got a date, in Orange County, the judges typically issue an order preliminary to a fee hearing, which sets forth deadlines for the production of time records, for expert reports, for objections, and all these things that have to be done before the actual fee hearing takes place. So we filed our time records. Progressive had our time records. We were asking for approximately $16,000 in attorney's fees for this particular case. Progressive had our time records for nearly 9 months before the fee hearing. Progressive's expert filed a report, and that expert sought to cut our appellate time by 40%. So they were asking for a 40% reduction in our time. So in compliance with the court's order preliminary, we hired attorney Hans Kennan from Morgan & Morgan to be our fee expert. And Mr. Kennan, again, as required by the court's order, prepared and filed an affidavit in this case, an expert report, which was sworn to and signed by Mr. Kennan. That was filed with the court in advance of the fee hearing. The fee hearing was set to occur on a Monday, and around 4:45 p.m. the Friday before the fee hearing, Progressive's trial attorney, not Mr. Hazuri, but Progressive's trial attorney, showed up in the lobby of my office and presented a check for 100% of the time that was represented in my timesheets, as well as the hourly rate that we had requested and that Mr. Kennan had testified in his affidavit was a reasonable hourly rate. So we proceeded to the scheduled fee hearing. Progressive argued, and the trial court agreed that Progressive did not have to pay Mr. Kennan's expert time because Mr. Kennan did not testify at the hearing. That was the argument that Progressive made. We argued that Florida Hospital was entitled to its expert cost because Mr. Kennan testified in the form of an affidavit, and that the affidavit was required by the court We did not have a lot of time to prepare for these arguments because of the late notice of the issue. And Progressive also argued that it was entitled to a dismissal with prejudice because it had it claimed to have settled all the attorney's fees and costs when really there was no settlement because we had not reached an agreement on the cost issue. And we argued that we are actually entitled to a final judgment of attorney's fees and costs because what Progressive had done was it withdrew any objection to our hourly rate and hours expended. So therefore, we are entitled to a final judgment of attorney's fees and costs. We filed a motion for rehearing and the trial court denied the motion for rehearing. So we're here today asking the court to find that the trial court abused its discretion in concluding that Florida Hospital was not entitled to reimbursement for its expert witness costs. We're also asking the court to reverse the final order of dismissal and remand to the trial court to enter a final judgment in favor of Florida Hospital based on Progressive's confession of judgment. So in preparing for the oral argument and going through the briefs, really what this case comes down to is, did Mr. Kennan testify? I think that's kind of the initial question. Did Mr. Kennan testify at the fee hearing? Progressive in its briefs rely on Florida Statute 92.231 as a substantive law establishing an expert's entitlement to cost and stating that it has to testify, the expert has to testify. Well, our position in this case is that Mr. Kennan did testify. The statute does not define the word testify. So when a statute doesn't provide a definition, the court is free to consult with the dictionary to come up with what the common usage of the term is. So in our briefs, what we've done is we've gone to Black's Law Dictionary, and it doesn't define the word testify, but it does provide a definition for the word testimony.
Well, let me ask you this, Mr. Barr. I mean, in your reply brief, you're very succinct first sentences. The issue in this case comes down to whether Mr. Kennan's court-ordered affidavit is considered expert testimony as required under the statute. You made that argument below. You made that argument in the motion for rehearing. Did you make that specific argument in the initial brief? And if you had not, is that fatal to your case here?
Judge, I think our position all along has been that Mr. Kennan testified. And the question, Progressive never raised, I don't believe, the issue, and I have to go back and look at this point, at the hearing, the issue of 92.231. What I recall from the hearing was that we were provided 3 cases, and I was not provided that information prior to the hearing. So I was provided that information during the hearing.
No, I think my point, I think you raised it fine below. I mean, and you raised it in the motion for rehearing, I believe. And you like I said, you succinctly raised a reply brief. If you didn't say it, in the initial brief, then there's a preservation issue, arguably. And I was just curious if you would, or I would be interested in you commenting on that. You seem to have gone on slightly different tangents in the initial brief. I mean, to me, the case is as you outline in the reply brief. Is this affidavit, this court-ordered affidavit, is it testimony under the statute when we consider that the statute doesn't define testimony, and Black's Law Dictionary says an affidavit can be testimony?
Well, I think that I believe that I adequately raised it. I'd be happy to address that issue again in my rebuttal time. But I do think that the issue does come down to whether it was testimony. And
you'll have a chance to look when Mr. Hazari is arguing.
I appreciate that, Your Honor. So going back to the definition, the Black's Law Dictionary definition of testimony, and it states that it's evidence that a competent witness under oath or affirmation gives in 3 different circumstances: at trial, in an affidavit, or in a deposition. So our position is that Mr. Kennan's affidavit was testimony at a minimum under 92.231. And Progressive, their argument is that they didn't have the chance to cross-examine Mr. Kennan and so on and so forth. And really, that's their own fault. They had the ability to take the deposition of Mr. Kennan if they wanted to. They could have asked for it. They chose not to. They could have cross-examined Mr. Kennan at the hearing from his affidavit. They chose not to. They waited until after they got his affidavit to choose to pay the claim and now are asking this court to, or making the argument that they should be protected under that circumstance. Also, this brings to light the issue of the Uniform Guide to the Taxation of Costs, and that clearly states that an expert should be reimbursed for its time spent preparing a court-ordered affidavit or court-ordered report, which is what Mr. Kennan did in this case. And this issue was addressed by this court in Smith versus Unum Life Insurance of America, where this court found that the trial court in that case abused its discretion for failing to tax the time spent by an expert preparing a court-ordered affidavit. What's interesting,
but in Smith, the expert actually testified, though, right, in front of the magistrate.
Judge, that was in a mediation, so that was not testimony before the court, and that was not testimony in a deposition, from what I recall from that case. So I don't recall seeing where the issue came down to entitlement. The ultimate issue came down to entitlement because the expert actually testified. My understanding was that the case went to mediation.
In Smith, it says a special master held an evidentiary hearing wherein both parties presented expert testimony and introduced numerous exhibits. Special master recommended a reduction in the attorney time based on various factors, et cetera. So in that case, we have somebody actually testifying, and the issue was, if I'm understanding, our issue was the trial court did not allow the time for preparing the expert witness report.
No, Judge, I think I disagree, but I'll do it cautiously. But I think that the magistrate's hearing was asked to the issue of attorney's fees. I don't think that the expert who prepared the report, because that report was required to be prepared in advance of mediation as to the substantive issue in the case. The magistrate's hearing was a hearing as to attorney's fees and cost. So the expert, I think those are two different issues in that case. The expert whose time they were trying to tax in that case didn't testify. They were seeking to get that expert's time as it related to a mediation report he was required to complete by court order. So I think that this court's mentioning of an expert testimony at the magistrate hearing was in regard to the fee hearing. And again, I will cautiously disagree, but that was my understanding. And again, I will go back and look at that as well. Again, in Smith,
excuse me, you've talked about the subparagraph 2 of 92-231 on whether or not the expert in this case testified. If we go back to the first subparagraph, the definition of expert witness, one who is permitted by the court to qualify and testify. What does that mean? One who is permitted by the court to qualify and testify as an expert witness. If that doesn't apply to your expert in this case, isn't that the end of it?
Well, are you saying that because the expert was not qualified? Is that the question?
Well, I'm asking what this means. One who is permitted by the court to qualify. Did that ever happen?
Mr. Kennan, I apologize. I think Mr. Kennan's affidavit clearly qualifies him as an expert. And the fact that Progressive did not challenge whether he was an expert at all in this case, and despite the fact that they had the opportunity to, they accepted his affidavit as it was. There was no objection raised, and his qualifications are clearly laid out in the affidavit that he is an expert. So I don't think that there has to be an official finding by the court that he is qualified to be an expert if everything is there. Wouldn't
that go against the idea of using an affidavit as testimony? If the court has to permit and qualify the witness as an expert, wouldn't that sort of imply that this needs to be in court?
Judge, I don't think so, because again, the qualifications of the expert are in the affidavit, and Progressive had the opportunity to counter or challenge those or object to that. And
I'm not saying he's not an expert. I'm just asking you what you think this means, that to be permitted by the court to qualify. And those aren't my words. That's what the statute says. What does that mean?
I think that the expert can be permitted to qualify himself as an expert based on the qualifications that are in this context that are found in the affidavit.
Okay.
And then we have the additional issue of the court dismissing the case. My understanding of the court's order and the effect of it is that it was a dismissal with prejudice when there already was a final judgment in the case.
If we rule in your favor on the first issue, does the second issue matter all that much? I mean, when we perfunctorily have to set that aside too?
I don't think so, but I think the court passing on the issue so that the end effect is not a dismissal with prejudice because that negates the final judgment that the court had already entered and had been affirmed through 3 different appellate levels. So in this case, the court we would be asking the court to remand, award the cost, but also instruct the trial court that it has to enter a final judgment of attorney's fees and costs and not just a dismissal.
The only appealed order is the order dismissing the case. So if we would grant relief, we would have to set that aside, wouldn't we?
I agree with you. It's just cautionary to the trial court to say you can't just award costs and then dismiss the case again. There needs to be a final judgment because of the progressive not objecting to the appellate time. Judge, I reserve the rest of my time for rebuttal. I appreciate it. Thank you.
All right, very well. All right, counsel, go ahead.
May it please the court, Ken Azuri here for the appellee progressive. And it's nice when the stars kind of align because the questions and issues that Judge Lambert, you and Judge Harris raised is exactly where I plan to go with my outline. I wanted to first point out that as Judge Lambert, as you noted, the very first sentence of the reply brief narrows this whole thing down to, in Florida Hospital's view, of whether Mr. Kinnon's affidavit was testimony for the purposes of 92.231. That's entirely different than what was argued in the initial brief. The initial brief made multiple other arguments, and I believe you're correct, Judge Lambert. There was no argument that the affidavit is testimony under 9.231. We can see that under the 4 corners of the initial brief, and therefore it is waived. As you pointed out, setting aside the waiver issue, if we want to presume or assume arguendo that it was preserved, then what you would do, the first step is, which now seems to be conceded, is you go to Florida Statute 92.231 and you read the language of that statute, which takes me to the issues that Judge Harris raised. And the starting point for reviewing that statute based on the new argument that an affidavit can be testimony under that is subparagraph 1, the opening paragraph where it says the term, and I'm going to skip the non-germane language, the term quote unquote expert witness shall apply to any witness who offers himself or herself in the trial of any action as an expert witness and who is permitted by the court to qualify and testify as such upon any matter pending before any court. That is a definition of a testifying expert witness whom may be awarded, for whom the party calling the witness may be awarded a cost, have that expert's fees taxed as a cost under the discretion of the court. Let
me ask this hypothetical then. All right, let's Mr. Bars listen to this play out. Let's, for the sake of argument right now, and obviously we're not deciding, the sake of argument, he loses today. And he says, okay, I've now got my marching orders from now on. Anytime I'm going to try to get expert witness fee tax, the attorney's fee tax, I'm going to depose my expert, file that, and I will use that because that will qualify as testimony, and expert witness deposition testimony is taxable. Wouldn't that be the route to take to avoid this discussion in the future for him?
Conceivably, then I guess you would, first of all, that would put you into a discretionary situation with the trial court, where the trial court would still have discretion, because even if the expert witness complies with 92.231, there's discretion there. So
right, that'd be hard to argue that it would seem to be an abuse of discretion for a trial judge not to award an expert witness fee at that point when you have to present an attorney to testify as to expert witness fees, and that's their expert. And let's say the expert's going to be gone for 3 months during the time of the hearing, and so they present it that way. And
sure, well, I'm sorry, you died.
That would. We have an interesting argument today about affidavits constituting testimony under that statute. Future cases, though, I guess that would avoid that discussion, because there's clearly their case law that allows expert witness testimony presented by deposition that's reasonably related to the issue, et cetera, and the trial judge has the discretion to grant. I mean,
Yeah, Your Honor, I agree with you that the hypothetical that you have posed would eliminate the conversation, the question of whether an affidavit constitutes testimony under the statute. You also said, let's say hypothetically, the expert is not going to be there, for the evidentiary hearing. So they take the deposition for use at the hearing. That's a classic use of, recording.
It doesn't have to even not be there. You can always use the expert testimony by deposition.
I agree. I agree with that. But my point is, let's just take a situation where, okay, and you used Mr. Barr, not casting aspersions, but you said Mr. Barr could do this in the future. Mr. Barr says, well, I don't like the way Florida Hospital Pena turned out, so I'm going to depose all my experts now, and I'm going to bring them to the fee hearing. Okay, well then, and I'm going to bring them live. Well, then you're getting into, maybe it's more of an issue of amount or what have you. I'm not sure, but you're getting into a situation where maybe that's abusive. I think my point is, I think it all depends on the specific circumstances of the situation, and it would all fall within the discretion of the court. And it's an interesting issue, but it's certainly not the fact pattern that we have here today.
I understand that. Go ahead.
Did I answer your question?
Yes, sir. Thank you.
So thank you. So your honors, so getting back to the very pointed and correct questioning that Judge Harris directed to Mr. Barr, you look at subparagraph 1, and that defines who an expert witness is for purposes of this statute. Now, Mr. Barr's response was, well, Hans Kinnan was qualified. Progressive didn't challenge his qualifications. He put some qualifications, very minimal, in his affidavit, all entirely irrelevant as to whether Mr. Kinnan is actually qualified to give expert testimony or whether Progressive challenged it. As Judge Harris was pointing out, this is an issue of statutory interpretation, regardless of Mr. Kinnan's qualifications or any challenge there too. And when you read the statute, an expert that testifies is, quote unquote, one who is permitted by the court to qualify and testify as such upon any matter pending before any court. It is undisputed that Mr. Kinnan the court did not permit him to take the stand, qualify himself to testify as a fee expert, and testify as such. So I believe, I'm paraphrasing the words of Judge Harris, that ends it. We're done.
What do we do then with statements from the first and the third most recently in the University Property Casualty versus Desfund case, that the general rule is per the statute. The statute says shall in those circumstances, but under certain other circumstances, cost that an expert incurs in preparing testimony, even though it becomes unnecessary, is taxed.
Yes, Your Honor. I believe in those cases, I'm not sure exactly which case you're referring to. I don't have a friend, but I believe in those cases there was at least deposition testimony from the expert. So then that raises the issue of, okay, now you're
not necessarily is what this case says, even though the cases stand for the proposition that just the fees in certain circumstances for preparing for the testimony, even though it becomes unnecessary regardless of deposition or trial testimony. So the opinions instruct that trial courts should reconstruct trial strategy to determine what a reasonable party would have developed in actual trial and award costs on the basis of that strategy.
Your Honor, again, I don't have the case in front of me. I don't recall it being cited in the briefing, but what I would say to you, if we're talking about expert witness testimony, and whether an expert can be, or whether an expert cost can be assessed against the opposing party, regardless of what any other district court says, this court has been exceedingly clear in its trifecta of cases of Junkus, KMF, and most recently Pilecki, which Judge Lambert was on that panel. So my response would be, to the extent any of these cases from any other district courts suggest that an expert that does not testify in deposition or at a proceeding, either a trial or an evidentiary hearing, can walk through the door and assess that expert's time against the opposing party under 92.231, there is a material conflict with this court's jurisprudence that I just read to you, and a material conflict with the plain language of 92.231 subsections 1 and 2. So again, the sole somewhat exception, and I would think it's more of a harmonization to 92.231 1 and 2 is Florida Rule of Civil Procedure 1.930C, which says that if an expert gives a deposition, he or she is entitled to be compensated for that, and that can be taxed as a cost. All the case law I've seen, including the Winter Park Imports case from this court, dealt with a situation where at a minimum, you had a deposition given by an expert witness. So I cannot imagine how under this court's case law and under the plain language of 92.231, an expert that doesn't testify at an evidentiary hearing or a deposition can walk through the gate that 92.231 creates, as clearly stated in this court's own jurisprudence of Junkus, KMS, I believe it is, and Pilecki. So that's how I would respond to that. And that ties into subsection 2, which adds to subsection 1 and says that an expert must have testified in any cause in order to have his or her witness fee taxed as a cost. So it's exceedingly clear that that you don't go past that, and this court's case law interpreting that. As far as the issue of the final judgment goes, as we pointed out in our briefing, basically what they're asking is a judgment that gets entered that allows the holder of the judgment to execute on the assets of Progressive, in this case, Florida Hospital, when the money's already been paid. Respectfully, that makes no sense. It makes no sense whatsoever that you cannot enter a judgment against a party for monies that party has paid to the supposed who's going to become the judgment holder. In this case,
how does this second judge, I mean, if I'm understanding Mr. Barr, he's concerned that this second judgment of dismissal with prejudice somehow affects an earlier judgment that was entered in this case, I guess, regarding the PIP benefits. What's your response to that?
My response is I don't believe that's Mr. Barr's argument. The judgment on the merits has been entered. It's been paid. It's done. Either it was entered or Progressive confessed judgment and paid the benefits. I believe what Mr. Barr is saying in his briefing is that the court lacked jurisdiction to enter a dismissal order because it had previously entered a final judgment on the merits. I don't think he's saying it has any deleterious effect on that final judgment. And so the first answer is the court does not lack jurisdiction. This is a separate collateral proceeding on Florida Hospital's claim for attorney's fees. And I don't think there are any costs claimed other than Mr. Kennan's affidavit. So let's just say attorney's fees. That was paid in full at $550 an hour for Mr. Barr for every minute that he claimed in the case. Okay, that renders the issue moot. Courts can always dismiss a case that is moot. Okay, that's standard case law. You'll find it in, we cited in our brief, Ahern versus Mayo Clinic. An issue is moot when the controversy has been so fully resolved that a judicial determination will have no actual effect. And there's multitudes of case law that says a moot case is subject to dismissal. So the question is, how does this proceeding get resolved? How do we wrap up the collateral proceeding, close the court file, say that it's all done and move on in light of the situation? The order that the court entered was perfectly appropriate for that, and in fact explained in great detail why it dismissed the collateral proceeding the way it did. There is zero harm, zero deleterious effect, zero problem with that. It was the right disposition. On the other hand, Mr. Barr is asking for a judgment awarding the same attorney's fees that have already been paid to his client, and we raised that, and I want to cover what his answer was in the reply brief. his answer was, oh, that's no big deal that there's going to be a judgment entered against Progressive allowing execution of its assets for a debt that it's already paid in full, because there's Florida Statute 55.141, satisfaction of judgments and decrees. Okay, so I pulled up that statute and looked at it. Let's read that one. This is what he's relying on. All judgment and decrees for the payment of money rendered in the courts of this state in which it become final may be satisfied at any time prior to the actual levy of execution issued thereon, thereby confirming that judgments can be executed on, as we all know, by payment of the full amount of such judgment or decree with interest thereon, plus the cost of the issuance, if any, of execution thereon into the registry of the court where rendered. So Mr. Barr's solution to the problem that he proposes creating is that Progressive should pay the same money they've already paid to Florida Hospital into the court registry in order to avoid having the final judgment executed on. Again, asking for a double payment on a final judgment. That's not the way this works. The court's order makes it exceedingly clear what happened. When collateral claim is resolved, it has to be finalized and put to bed by an adjudication, especially if somebody like Florida Hospital wants to appeal it, because they, as we all know, there would be no ability to appeal it and no jurisdiction in this court until a final order is entered. The trial court's order was perfectly appropriate to accomplish that objective, which was needed to bring this to an end. So I guess the only other comment I would say, going back to the arguments that Mr. Barr made, he referenced the uniform guidelines. For this particular situation where you're talking about taxing an expert cost, you do not get to the uniform taxing the expert fee as a cost against the opposing party. You do not get to the uniform guidelines until one of two things happens. The person seeking to tax the expert fee as a cost walks through the gate of 92.231 in the manner that we've just covered and looking at subsection 1 or 2 thereof, or alternatively, the party seeking to tax the fee as a cost against the other party walks through the gate of 1.390C, Florida Rules of Procedure 1.390C, by having its expert give a deposition, at least under the hypothetical that Judge Lander proposed, but more normally at the request of the opposing party. In that regard, Mr. Barr said it's Progressive's fault that it didn't take Mr. Kennan's deposition. Well, that's neither here nor there. It was a decision made by Progressive. The point is, he didn't testify at the fee hearing, Mr. Kennan, and he didn't testify in a deposition. Therefore, there is no gate that they can walk through to establish entitlement to the expert cost. So you don't even get into the analysis, which again, Judge Sasso, I believe, is what you raised, of, well, how much of the cost get taxed? Is it how much preparation time? If there was a report prepared, that's actually covered by the uniform guidelines. But the cases I'm familiar with say when you walk through one of those gates, and there's discussions about how much of the expert's fee should be.
The case that I'm referring to specifically says, fees for experts who never testified at trial and who were never deposed. But I think I understand your argument that that's just irreconcilable with the cases from the 50 CA.
Yeah, I'm sorry, I can't. I wish I had that in front of me, and I apologize. I don't have a specific answer based on the language of that case, but that would be my response: is if it's that clean of a ruling as you described it, then it can't be reconciled with Junkus, KMS, and Pilecki, or 92.231, or.
Well, Pilecki, there was no affidavits from the experts either. So, and there was no trial testimony. So I think it was just a one paragraph holding by the majority. Judge Evander wrote a concurring opinion about a different issue, but I think that Pilecki can be distinguished somewhat there compared to what we're talking about here. So.
Well, thank you for that. You were there. I wasn't. I didn't read the briefs in Pilecki. I would agree with you. It's a short decision. but it's significant for a couple of reasons. I don't want to beat the horse too much. I see I have a little over a minute left, so I'll use most of it up. First of all, there was an argument made in the initial brief that Juncus and KMS were outdated because they were decided before the uniform guidelines were amended. And that Pilecki both relied on those cases very recently, so it destroyed that argument. It was relevant for that reason. If Judge Lambert, you're telling us there was not a fee affidavit or any affidavit from the expert in this case, obviously I accept that. That's not written into the opinion, and that would take us back to the issue that's the very first sentence of the reply brief and all the arguments we've talked to about that Mr. Barr has basically limited himself to that argument, didn't argue it in the initial brief, and an affidavit doesn't get you over the finish line under subsection 1 and subsection 2 of 92.231. So, and Juncus, KMS, and Pilecki, although you said Pilecki is distinguishable. So on at least the affidavit ground. So at any rate, with that, I appreciate you allowing me to make the argument. We ask that the court affirm in its entirety the disposition of the trial court below. Thank you.
Oh, you're muted, Judge.
Counsel, thank you. All right, Mr. Barr, you've got 5:28 in rebuttal.
All right, thank you. So I went back to the brief, and I was quickly able to find in the brief that I did state in several instances that Mr. Kinnon's affidavit was testimony.
I mean, I know on page 17 and 23, you say the expert testified by affidavit. And I guess that the question is that, but that didn't seem really be your argument per se in your initial brief. I mean, you did make those comments. I do acknowledge that.
I think really the crux of the argument was that first and foremost, under the Uniform Guide to the Taxation of Costs, we're entitled to those costs, even if it's not testimony, because it's a court-ordered report. But at a minimum, he did testify in the form of an affidavit. So wherein the trial court found that Mr. Kinnon didn't testify, our argument was that he did testify and he did prepare a court-ordered report. So did I use the words that he testified under 92.231? No. And
those are two different arguments, though, isn't it? I mean, you're saying that on one hand that the affidavit is testimony when the guidelines pretty clearly say deposition and or trial testimony.
Well, the guidelines
and a court ordered report. So is the affidavit more appropriately characterized as a court ordered report or testimony?
I think it's both. I think the affidavit was court ordered. It certainly fits the realm of a report, but it also fits the definition of testimony under Black's Law Dictionary. So it's either.
Let me just tell you, here's how I understood your argument in the initial brief was an expert doesn't necessarily have to testify in order to get their fee. And alternatively, there's a court-ordered expert opinion by way of affidavit, and under Smith, you're entitled to fees. That's how I understand your initial brief. If I'm wrong, please correct me.
I think the bigger crux of the brief was that it's taxable under the Uniform Guide for the Taxation of Costs, but also rebutting the trial court's conclusions that Mr. Kinnon didn't testify at the hearing. He didn't have to testify at the hearing. He didn't have to testify in an affidavit. He testified in the form, or excuse me, he didn't have to testify at the hearing or in a deposition, but he testified in the form of an affidavit, which should have the same force and effect as a deposition, because we're required to prove the reasonableness, the lodestar, if you will, pursuant to expert testimony, which that was what our position was below, that we had done that. So I might not have clearly made that clear in the brief, but really what we were arguing was we did testify in the form of an affidavit. We did provide that testimony in the form of an affidavit, but also it's a court-ordered report. Judge Harris, to address your question about the phrase who is permitted by the court to qualify, I don't know that question in the context of an affidavit is any different than that question in the context of a deposition. Because when a deposition is given, the court doesn't qualify that expert at the point of the deposition being given. But clearly 92.231 and the guide says that those costs should be taxed. So the court
isn't that clarified though in a separate procedural rule allowing costs for deposition of experts?
Well, I think, but they all tie in hand. So what this is saying is that the under 92.231, Mr. Hazuri's argument is that he has to testify, which means he has to testify under oath at either a deposition or a trial. And what we're saying is that he's not qualified during a deposition, and may not even be qualified during a trial if he begins his testimony and the defendant agrees to confess judgment while we're in the process of the voir dire. I don't think that the court actually has to make a finding of a qualification if those qualifications are in the record. And I think, what we have in this case is a detailed affidavit listing forth his qualifications as an expert. So I think that Mr. Kennan's affidavit satisfies 92.231 and also satisfies the guide. I hope this court understands that these order preliminaries are being issued by nearly every county court in the state of Florida now in advance of a fee hearing. So what an affirmance will do is will allow insurance companies like Progressive to push these issues to fee hearings and then completely dilute the ultimate fee awarded by saddling the party requesting the fees with the expert costs that are required to be incurred by both Florida law and these order preliminary to fee hearings. So finding that the affidavit of Mr. Kennan is testimony under 92.231 and taxable under the guide it is appropriate and is necessary in the state of Florida. So we would ask the court to reverse for the arguments presented in our briefs. Thank you.
Do you agree if you depose this expert though, then that would take this issue off the table, right? And people depose their own experts, obviously. So
well, the question is, how are we interpreting 92.231? So the first paragraph, in that instance,
if you depose the expert, then you would get taxable costs under 1.390, right?
But if the court doesn't qualify the expert as an expert, I don't know.
Well, I mean, summary judgment hearings, the experts, that's taxable costs. You don't have a separate hearing to bring the expert in and for the judge to say, okay, that deposition that was used in support of the summary judgment, I qualify that person as an expert and I therefore tax costs. I mean, they assess costs all the time under 1.390, right? This is just a different setting and this statute applies. I mean, an award of taxable costs can be either by rule or by statute. It seems like the scenario here is we're falling under the statute because there's no deposition. This was not a 1.420 scenario like the Coastal Petroleum case. So, we're left with this because the guidelines are advisory. They're not substantive, right?
That's correct. I just don't think that the rules, the statutes, the guidelines were intended to make things more difficult than they need to be. And in this instance, the affidavit was filed. Progressive could have deposed Mr. Kennan and chose not to.
Okay. All right. Thank you very much, counsel.
Thank you.
We'll stand adjourned and take it under advisement.
Thank you.
Very much. Nice
Have a
seeing
good
you.
day.